Ciao a tutti. This is Prof Jo at Prof Jo Explains, and this is a recap of the trial in Paul Carrera for the murder of his brother, his sister-in-law, his 8-year-old niece, and 11-year-old nephew in a particularly brutal manner. And today we started really digging into the evidence that the state has against Paul. But I'm going to start with the judge who amused me no end because he said at one point today, 12 times that question has been asked and answered, and the prosecutor didn't get up on his feet once to object. Now, if you take from that the judge thought we were wasting time, you would be right. There's Judge Lemieux. And if you take from that the prosecutor was being chastised about it, you would also be right. An indirect chastising because the judge didn't say anything directly to the prosecutor, but oh boy, did he make his feelings clear, as he did the very first day of the trial, and as he's intimated all along. But today we got a really strong version of it, and he was right. The question was asked and answered and asked and answered ad nauseum. Also, the defense lawyer, Murray, went outside the scope of the direct at one point, and the judge didn't like the fact that the prosecutor didn't object to that. But he said to the prosecutor, he went well past the scope of the direct, and so I'm going to let you have a chance to do another redirect. There had already been a direct, a cross, a redirect, and a recross. And the prosecutor said, "That's okay. I don't have any more questions." And I don't think the judge was thrilled with that either. He gave him an opportunity to ask some more questions on redirect because the defense had done things that he's gone beyond what the scope of the direct was. And in other words, he asked questions that he wasn't entitled to ask. And the prosecutor didn't believe that he needed to do anything. And I don't think the judge thought that was the correct approach. The judge has many years prosecutor experience, and he wants a tighter ship. That's clear. If we weren't doing all this repetitive stuff, we would be, I think, at least a half day further on in this trial, maybe an entire day, because there's a lot of it going on. But on the other hand, I will say that I think the prosecutors are doing a very good job getting their evidence in, and I think they will continue to do so. And I think the defense is doing a good job poking holes where they have the opportunity to poke holes, and making a little clearer today that the defense is going to be, Paul didn't do it, his brother Corey did. So that's a kind of a snapshot of the sort of the overall day. We started out with Laszlo Cardenas, if I'm pronouncing his name correctly, and he's an estate planning and probate lawyer. And I think probably a very good one from his testimony today. I was really impressed. And he talked about a little about what estate law is, what probate law is, what irrevocable trust is, what an irrevocable trust is. And I'm going to focus on irrevocable trust because that's the trust that that Keith set up for his wife and kids. At the time he set up the trust, he and Jennifer were not yet married. I think this witness said it was another couple of years before they actually did get married. But probably wasn't this witness because he didn't know them. But anyway, they weren't married at the time. And of course, he had no children at the time, but he set up the trust. He only put $1,000 in to start the trust. And the defense intimated that, that was a very strange thing to do. And the estate lawyer said, no, a lot of people set up the trust instrument and then they start putting funds into it as they go. And this trust was set up to permit funds to be added later. So we have the irrevocable trust. And for those of you who didn't listen to him today, describe the irrevocable trust. The irrevocable trust is I take my money and I give it to the trust. It is now the money of the trust. It is no longer mine. It would be like I took $1,000 and gave it to you, as an outright gift to go on a trip. It's now your money. You can do whatever you want with it. I cannot control it. That's the trust. Within the trust, the owners of the trust are the beneficiaries, and the administrator of the trust is the trustee. In this trust, Paul had set it up. I want to say Keith had set it up, as I said, for Jennifer, who then he did marry, and the children that might come, and that was the 8 and 11-year-old who were, all three of them were killed. And he created in the trust his brother Paul as the trustee and gave him very broad discretionary powers under the trust. In other words, this trustee, his brother, was not limited in how he administered the trust. Now, the trustee is supposed to do things to inure to the benefit of the beneficiaries. If I've got money and I just stick it in a savings account so it's making very little money, I'm not doing a very good job of managing my money. So too with the trustee. The trustee is supposed to be managing the money in a way not only to preserve it, but to increase it for the beneficiaries. That was Paul's job, and there were probably no real limitations other than what the law would require in terms of what Paul was able to do. Then at some point, Keith did a life insurance policy with the trust as beneficiary, and that was part of the trust. And the trust was supposed to pay the premiums on the policy. And earlier today, I got a question about why would the trust be paying the premiums on the policy? It's because now the trust owns the policy, and the trustee has the obligation to pay the annual premiums, or whatever they were, quarterly premiums. In the same way, if you had a life insurance policy, you would be obliged to pay the premiums. Otherwise, you might lose the entire race or the money that's in your insurance policy, because you will have forfeited by not paying your premiums. So the trust was supposed to pay. Excuse me. The trust was supposed to pay the premiums. And if you recall, that's what turned out to be where this argument started. The accountant for the company that Paul and Keith owned together, Keith had 90% of it, Paul 10%. It was the company that did IT and that sort of work. And also, he was the accountant for the waste removal company that Paul and Keith also owned. And they had discovered, he and the accountant had discovered, that Paul had not been making the payments, the premium payments on the insurance policy. And of course, he's got a fiduciary obligation to do that. And in addition, seemed to be taking money from the trust race to use to pay his own bills, personal, that didn't go into any business use, even if he could, and he wasn't supposed to do that anyway. And you recall that was the person who testified about all this was the police forensic expert, and she testified, I think, last week, first or second day of the trial also. So anyway, we learned also that the contingent beneficiaries on the trust were Paul and his brother Corey. Now, contingent beneficiaries, that means if the beneficiaries, the primary beneficiaries, are not alive, they're deceased, then the beneficiaries of the trust are the contingent beneficiaries, and that would be Paul and Corey. So what we have here is Keith having a close relationship with Paul, certainly fully trusting his brother Paul. Otherwise, he would never have made Paul the trustee on the trust that he was setting up to make sure that his wife and children were taken care of in case he died. And he finds out, this is what the state's case is, that his brother Paul is not managing the trust appropriately, is angry about it. He and the accountant had talked about what might be done. He started having sending messages to Paul about what's going on. And The state alleges that what happens is Paul decides that the way to get his brother off his back and also then be the beneficiary of the insurance policy, which will obviously come due if Keith is dead, he kills his brother, he kills his sister-in-law, and he kills the two children. They are the primary beneficiaries on that insurance policy. And now he and Corey are the contingent beneficiaries. They now are the beneficiaries of that trust. So that was the evidence that we got from the trust and estates expert. He was not the person who set up the trust for Keith. He was the expert witness that was called to explain what estate law is, what probate is, and then to evaluate the trust instrument itself, to talk about what the trust instrument looked like and what the obligations of the trustee were. And he got some questions on cross-examination. I thought the defense lawyer did a really very good job of trying to get from this expert witness some evidence that would help the defense, because the defense lawyer said, well, I understand that the theory in trust is the donor, the settler, the person who sets up the trust, Keith, once the trust is set up as an irrevocable trust, has hands off. There's nothing he can do or say with regard to the administration of the trust. Who does it then? The beneficiaries. And so then Mr. Murray, the defense lawyer, said, but here it's a family, it's the brother who's the trustee. Isn't it likely that the brothers talk? And even though the law says the trustee has to, the settler has to have hands off, they talk anyway. And as an aside, the reason why it's irrevocable and the settler, the donor, the Keith, has to have complete hands off is the trust means you have no tax liability or obligation on that money because it's no longer yours. Once I give you a gift of money, you could invest it and make lots off of it. It's not income to me. It's not my money anymore. And that's how the trust is. But it has to be irrevocable for that to be true. If I still can have my hands in the operation or the administration of that trust, then it's still mine. And if it's still mine, I have tax responsibility with regard to it. So hands off, but it's a family. They might be talking about it. The defense lawyer also said to the expert, can you be sure that the lawyer who set this up explained to Paul that he had a fiduciary responsibility to maintain the trust, the assets of the trust, and an obligation to pay the premiums? The expert said, well, I wasn't in the room. I can't testify to that, but any lawyer would do that. The defense lawyer said, but you can't show that he did it, and it's a close relationship, and doesn't that affect things? And my comment here is, I thought the defense lawyer did make a good point about the close relationship. Maybe they did talk. And on the other side, Keith may have felt that if the trustee was not acting appropriately in being the trustee of the trust, since he set it up, that he would have the right to intervene and do something. Law doesn't let you do that. It's the beneficiaries that have to do it. But Keith may have not understood that. So I thought that the point there was pretty good. But the idea that Paul would have thought it was okay not to pay the premiums, or that it was okay to take money and use the money for his own purposes, seems to me to be something that the jury won't buy, because you don't have to know any trust law to know that if you're entrusted with money for the benefit of somebody else, you can't pocket it yourself. And if you're entrusted with paying premiums on a policy, you've got the obligation to pay the premiums. But otherwise, I thought the defense did really a pretty good job there, suggesting that the relationship was such that it wasn't so clear. The defense also said, well, you don't know if Paul didn't tell Keith orally that this had been occurring, even though the trust said do it in writing. And the notice shouldn't have gone to Keith about what was going on. It should have gone to the beneficiaries. Nonetheless, you don't know, maybe he talked to him, orally. It's possible. The rub here is that the people who should be noticed if something is going on in the trust. In other words, with this trust, Paul could have borrowed money from the trust or even taken money from the trust with the consent of the beneficiaries. Now, the two children can't do anything, they're children. The defense lawyer said, so then it would be Keith as the guardian. So even though as the person who set up the trust, he has nothing to do about the trust, as the guardian for the beneficiaries, he still can intervene to act. Now, I will say as a start, I'm not an expert in this area. I don't know whether you can set up an irrevocable trust and then be the guardian for the children for whom the trust is set up and avoid tax consequences. I have no idea. But at least the defense lawyer opened that possibility up to the jury as something that might have been going on. The difficulty, though, the difficulties are two. One, Jennifer is not a child, and Paul would have had the obligation to notice her directly in writing, according to the terms of the trust. And two, the evidence that we've heard already, and I think we will hear more of, is that Keith did not know, and he certainly didn't consent on the, as the guardian for the children, that Paul do what he was doing with the money or the non-payment of premiums, because we know that the evidence is showing that Keith was pressuring Paul to explain what had happened and what was going on. So that doesn't sound like somebody who's consenting on behalf of the children for Paul to do what he was doing. So anyway, that was the evidence from the trust and estates person, and I thought he was very good. And if you have lots of time available, you might want to hear him, because you would learn something about managing your own money and what the trust is like. So you could get a quick lesson from an expert on it. I thought he did a very good job. So then we had, we started with the next witness was, I believe, let me think about this a little. Yeah, Dennis Cortona. I've got his name wrong again. I have to find it here. I know I wrote it down. If I don't write the Capora. And there he is now. He was quite the witness because he was in a track testifying. And if he got moved off the track, he started from the beginning to tell you what had happened. He woke up, he heard shots. His first thought, he asked the judge if he could say this, was somebody got whacked. And he lay in bed a while wondering what he should do. Should he phone? What should I do? What should he do about it? Then he got a question, and he started right at the beginning. He heard the bang, 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 boom. And then his first thought was somebody got whacked. I mean, you couldn't, if you asked him a question, you were going to go back to the beginning and hear the whole story. So we heard the whole story 3 or 4 times, I think. But in any event, he lived the evidence, or at least the defense lawyer said, a couple of miles away. And he heard these shots. They didn't sound like a shotgun, didn't sound like a rifle to him. He was sure it was a gun. He thought about whether to phone, what to do, and then he phoned a 911 and said he had heard these shots. He said he started out because he didn't want them to think, I don't know, he said it quite this way, he didn't want them to think he was a kook. So first he said, are people in this area, is it legal to go deer hunting in the middle of the night? And the answer from the person who took the call was no. And he said, well, I heard these shots. She said, well, send somebody out. He waited a while. He went back to bed. He waited a while, wondered what was going on. He called 911 again, and she said somebody had gone out and didn't find anything. So that was his evidence, but he was critical on the timing. And you remember I said last night on the recap that there was evidence yesterday of this car that had gone from Keith's house to Paul's house, that stretch, and the officer did it, and it took him 19 minutes, and they had a firm dead time at which that car left. And his evidence, when he heard the shots, would give you the window in which the murders had to have been done. And it could have been as short as 15 minutes, depending on what this witness said. So our friend, the defense lawyer, who wants witnesses to say exactly what she wants and can't find a way to get out of wanting that, was back to her old familiar habit, because the police report said that this witness had said he waited a minute before he called 911. And she asked him, so you said 1 minute? And he said, I said a minute. And it could have been, a minute. And, I wasn't looking at a clock. She wanted him to say 1 minute. He wasn't going to say 1 minute because he said a minute, which didn't mean for him it was 60 seconds and no more. But that's what she wanted. She didn't get it from him. She pushed and she pushed. And just like yesterday, when I thought she helped the prosecution, he finally said, well, a minute. It could have been 2. It could have been 3. And I think he also said it could have been more. That I might have made up while I was listening to this. But in any event, she didn't nail the time down tight. She actually, through him, allowed him to expand the time a little. So there's a window there, and each side is going to argue how many minutes it was. And we had people in the chat today. There she is, trying to get him to say it was this much, and there was 1 minute and no more. And she won't give up on it. I don't understand it. But they will argue in closing what the window was. The prosecution's going to have a wider window than the defense does. The prosecution also, I don't know, might end up saying that car might not be the one that Paul used. We don't know what will happen. I think they are going to say it's the call, that's the car, because they spent a lot of time with it, but we will see. But people in the chat said, well, in 15 minutes, particularly with adrenaline flowing, you can get all this done. Now, what he had to do in that time frame, whether it's 15 minutes or 20 minutes, he had to park the car, get to the house, pull the lid off the meter, pull the meter out, wait for Keith to come out because the electricity was out, and we don't know how long that would take, shoot and kill Keith, and that was the bop, 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 boom. And that last shot was probably the shot to make sure he was dead. My guess, that was not in evidence. Oh, and our witness, our Dennis, had said the boom didn't mean it was a different gun or anything. It just meant that there was a long pause before the final shot, which makes it sound as though, if you imagine it, I imagine it as he shoots him however many times and then walks up to him and make sure he's dead by shooting another bullet into him. And then in that time frame, he then has to go into the house, and apparently that door on the side, the neighbor last week had testified, the father of the little girl who used to play with Keith's daughter, that the door to the right, when you're facing the house, the door to the right of the front door was typically left unlocked, and Paul would know that presumably. He had to go in, kill his sister-in-law, and then what he did, I don't know why he moved to a knife, but he knifed the 2 children, and then get back out to the car and be on the road within that 15 or 19 or 20 minute period. It's doable, clearly, but it is a short time frame. So then we had somebody from the Morris County Prosecutor's Office who, and if we've got a tape of this or a video of this or a picture of this, I want you to see it. We saw more pictures of a dark screen with little lights flickering. And I said, because I'm not visual, for the life of me, I hear what they're telling me it is, but I don't see any of it. And some of it was the car in the driveway pulled in, did a K-turn, and came out. Defense lawyer said, well, couldn't that be when Paul, after the fire was discovered, he got his family out? Then he said he went back into the house to get the car out of the driveway in case the emergency vehicles needed to access the driveway. So, and the police officer, and I think it was around 5:01 that these little flickering lights were the car doing that, maybe 4:50, somewhere in there. The police officer said yes, or the prosecutor's officer said yes, that could be it. So I don't know why we spend time with that. In fact, I don't know why we spend time with all these Okay, Amber's still trying to find it. Well, we're going to find one for you, and you tell me. Black screen with these little flickering lights, and they're telling us what it is. Some people in the chat thought they could see the car or had some idea what was going on. I had none. None. And since somebody like me who's not visual at all might also be on this jury, I didn't know what these pictures or these were videos were designed to really do. But we saw a lot of them. Maybe not as many as I think we saw, because I couldn't see what was going on. And so for me, we saw millions over 5 hours. We probably saw, I don't know, 10 minutes. I don't know. It has to be more than 10 minutes. Anyway, I hope Amber can find it for you, because it was quite the experience for me. Enough of an experience that I'm even willing to stop to let her look for it. And I know she has it, because I asked her today and she said she did, because it was just remarkable. But we will go on, and whenever she finds it, we will stop so you can look at what we were treated to, just one little piece of what we were treated to for hours. I say hours. You can not believe me, and you would be right not to believe me. So then we got we ended up with two officers. There it is. That's what we saw. You see that? You see the top left? Now that's supposed to be, I think, a driveway and a car. I can't swear to it because I never knew what we were talking about. And at times, there would be lights flickering other places on the screen. I thought at one point, I thought we were looking at the Big Dipper. Another point, it looked like there might be UFOs out in the sky, because this looked like sky to me. I couldn't, but imagine this. We saw a lot of something like this. And at one point we saw a big, sort of, it looked like a fire, and it might have been the fire from the house, but I don't know why we were looking at this. So, but you look and see what you think, because it was quite the experience. That's where he started. But then he was the person, he talked about some of the evidence, and he was the one, I think, who actually secured the DVR that was in the garage. But they got into, he and the defense lawyer, Mr. Murray, got into a discussion about the DVR. The DVR was hardwired. It did not work on Wi-Fi. The Ring camera on the front door worked on Wi-Fi. This officer got the consents to seize and search the DVR and the consent to search the car. There he is. I thought he was a really good witness, actually. He was the one who talked to Paul in the car, obviously, to get the consents. We spent some time with the defense lawyer talking about whether, Paul could revoke. Paul didn't have to sign. Some of it was silly. At the point he was trying to make was, if Paul were guilty, would he agree to have you look at the DVR? Would he agree to let you search the car? He willingly and cooperatively and without any pushback signed both of those consents. So, a little point, a minor point, but a point for the defense nonetheless. But the DVR being hardwired and the Ring camera being Wi-Fi did come up for a fair amount of discussion, because what Paul said in the car was something about connectivity issues with the cameras. That's what the officer reported that Paul said. But it turns out that the connectivity issues were Wi-Fi. The DVR was not Wi-Fi. So the officer said, I did not know that. When I talked to him, it was only after we took the DVR down and brought it back to wherever they brought it that they saw it was hardwired. It did not work through Wi-Fi. So at the time, but he didn't say this clearly, at the time he was sitting in the car, when Paul's talking about connectivity issues, he thought it meant the DVR. Thought it meant all the cameras. And that was reasonable, because he didn't know at that point that the DVR was hardwired. The defense lawyer, taking a page out of his partner's book, wanted him to say that he knew when he was sitting in the car that the DVR was hardwired, and therefore he knew that there was no issue with the DVR. They went back and forth on that. The other thing that the defense lawyer wanted him to say was that there had been an episode with the cameras, the DVR, in November. And this officer had, because Paul had talked about connectivity issues, had gotten in touch with the manufacturer or the service people for the DVR and the cameras and asked for incident report. I'm calling it an incident report. They called it something else, about any issues with those cameras over, I don't know how far back they went, because Paul had said he called in a complaint or a service request, and their records show no interruption of service from those cameras, and they also show no requests from Paul. And the defense lawyer said, but we know there was this episode on November 19, and I wasn't clear what the episode was. I didn't hear if there was a witness who had testified about the cameras not working with evidence to support. It wasn't today, and it would have been maybe last Friday, maybe yesterday, last Friday, and it may have been a time when I was not, because I had to dash out a couple of times, or I came back late one time. It may have been then because I didn't hear it. But any event, I don't know that on the DVR, the Wi-Fi, that the defense lawyer got anywhere on that. He did say, but Paul could use his phone to access the video. And the detective said, yeah, but you can have an app that allows you to access the videos that have been taken, but the app doesn't run, the DVR doesn't run on the Wi-Fi. DVR is hardwired, but you might have an app that's Wi-Fi that will allow you to see the video that's been acquired. Made sense to me. The defense lawyer either couldn't understand it or didn't want to understand it and wanted to leave it sort of up in the air for the jury. So that was our second witness today. And then we got, or third witness. And then the final witness was also law enforcement. He's one of the forensic detectives at the prosecutor's office. And he was the conduit for talking about some of the evidence that was found. He had done a perimeter search, and a lot of evidence came in through him, pictures of the scene, and we're going to just show some of them now so you can see some of the evidence that was coming in. That's the gasoline can that was found near the garage. I thought it was a much bigger can. It's about, what did he say, 1.5 gallons, 1.2 gallons. He said he thought it was 2 gallons, but it wasn't. There was gasoline in it, and he kept a small amount of the gasoline in case they ever needed for forensic purposes, and dumped the rest of the gasoline. And this is some of the fire damage around the house that he talked about, and he took a picture of. We'll see you can see the char. You can see that's the fire on this is the back of the house where the deck is. And you recall last week, the fire people who were there said that it was on this side of the house. From the front of the house, it would have been the right side of the house. We're at the back, so it's the left side of the house, and it was coming from the basement area. And this is a good picture of that fire on what looked like a big deck to me. And he also took pictures of all the windows in the house. And here's some more fire damage. You can see it in the ceiling. And I think in the back there were 4 windows that he took a picture of. I mean, he just went through, and so we're seeing all the perimeter. And here's some evidence of some of the evidence he found. And I don't know what 9 was or 10 is. Now, maybe someone in the chat who was there today may recall what he said about this evidence. But this is him securing the evidence and making sure that there are photos to say where it was that the evidence was found. This is some of the fire damage, and you can see this is a pretty damaged area. And we're going to see a couple of pictures coming up that I think are really damning for Paul, uh, of what the video cameras took. And so we'll keep going. Oh yeah, this is one of them. This is someone who's, this is the girl, this is the basement, I believe. And there's a camera in the basement, and this is a notice from the company saying, your camera went off. And it could be, it could be a storm, it could be this, could be that, but you need to know. And this is a male in the house in the basement, and there is a camera there. It was one of two, forget what the cameras were, but this was one of them. And it seems to me this is going to be pretty damning for Paul, what he's doing in the basement at that time of day, since it's around, it was, the timing on when they get the alert from the company, is within the range of when the fire started. Okay, more damage. This is the garage where you can see some damage here. And we'll see our next picture of damage. We've got one other picture that it's important that you see that also pretty clearly, I think, implicates Paul. And so as you can see, the day was spent, oh, he's in the garage, bottom left. Let me see. Oh, sorry, there he is. You see, I'm just not visual. Do you see the blurred picture of the male without a shirt on in the bottom left? That's near where the other video camera, that's the one in the garage, the one that was near the refrigerator in the back of the garage. And there is somebody who sort of looks like Paul, but in any event, you've got two pictures of this male, near the cameras, and there's the camera. There's the refrigerator. The little red circle is circling the camera there at the time of the fires. So you can see that a lot of what we saw today, with the exception of the first person, the lawyer who talked about the trust arrangement and talked about irrevocable trust, was getting into the evidence. That we're going to start seeing more of the physical evidence that was collected at the scene, and we're starting to see the video camera evidence. Although, as I say, the camera with the black screen and the little white things didn't move me anywhere. But I'm not visual, and it may have helped others. So that's it. I don't know that there's anything more that I want to say about today. I think today was interesting. The judge was more, joked a little more, was more, sort of comfortable. He's been joking with the jury for a while, but he smiled at the defense lawyer and the prosecutor, and he seemed to be more jovial. But that was before they had this, he made his comment about 12 asked and answers, and the prosecutor didn't get up once to object. Okay, another Jersey girl here, a few miles from the courthouse in Freehold, enjoying your coverage. Thank you, Cheryl, 15768. Thank you for the gift. I hope you're subscribed. And the chat today, now, are you working? Because the chat today wanted somebody to go sit in and watch the trial and report to us on whether the jury was getting tired of some of the lengthy evidence from the video cameras and things. Okay, and here's Andra Popescu, who was watching the trial today. Anything indicate the defense relies on Paul's testimony? They must testify. I don't see anything that's come in that we need Paul to testify to that others cannot testify to. And I am certain that the defense lawyers are going to urge him not to testify. So we'll see. Oh, there it is. Okay, this is from Christine, who also was there this morning. In my opinion, what does the prosecution have to do, say, in closing, to bring together all the disparate pieces of evidence and convince the jury to convict? I think you had that question in the chat during the trial, and I didn't have a chance to answer it then. You saw the opening, or if you didn't, go look at the opening. What the prosecutor has to do in the closing is to go through the opening, to harp on the motive, even though motive is not an element, and and remind the jury of all the evidence that shows that Paul was fooling around with the money and not paying the insurance premiums, and that Keith had gotten at least exasperated about it, to show that was going on. And Keith kept saying, you got to explain, you got to explain, and then go through what the prosecutor did in opening, which is the chronology of events. And now we have the sort of the evidence that supports it. And if I were I would show some of these clips, not the black screen, but I think I would show the clips of the man in the basement, the man in the garage, and trying to think what else I would use, but I would use some of that to supplement, and that would be the closing. So, okay. Other questions? Isn't Sandy Hook, Seabright, Monmouth Beach the most northern shore points? I had said this comes up because I said Long Branch was the northernmost. I'm thinking of the New Jersey Parkway, and the first thing you hit on the New Jersey Parkway is Long Branch. So my geography is not great, and I don't have a map here. So you can look, Ollie, if you would look at a map, you can report to us, which you could get to first. I was really thinking of which, if you were driving, which shore area would you hit first? The last witness had been a police officer in Long Branch, and I was saying that was the closest, the most north. But I also was saying that had been it was a train stop, and the rich robber barons in New York, Long Branch was where they had their summer home. So there are these big, beautiful mansions there. And then for a while, Long Branch, had sort of, people weren't going there, and everything was got a little seedy. And in the last few years, it's had a resurgence, and it's upscale again. And the mansions have been refurbished, and it's really a very different shore area. I liked it when it was a little seedy, frankly. So, but it's different. Yeah. Okay. Any more questions? Because otherwise, we can end for the night. I don't see any questions, any comments. Anybody who was there this morning want to add his or her view about the trial? Okay, no, well then I will read one of these little poems if I can find one. This is the Shakespeare in three panels, and I'd like to do one that we would all know. Let's see if I can find Richard III, because we all know about Richard III. I think he was supposedly the hunchback king, and he really wasn't hunchback. He said, a horse, my kingdom for a horse, which is a kind of famous quote. Here he is. And they probably are not describing him, at least in history, the way he was, but certainly the way Shakespeare portrayed him. And he's the one, by the way, his body was found under a parking lot just a few years ago, because after he'd been killed in this big battle, they didn't give him king's burial or anything. And he was buried in the courtyard of a monastery, and they never knew where it was. And it's a great story. There are a few documentaries on YouTube about it. There's a society in England. It's the Richard III Society, and the society was really interested in finding his bones, and they thought that he had been maligned in Shakespeare's play, because it was the people who took power were, it's your enemies who took power. And so his history is the history of the people who won and he lost. It would have been like if we had lost the Revolutionary War, what would the story of George Washington have been told by the British? It's that kind of thing. But in any event, she was insistent, and she found some money, and she just, she was just indefatigable, and they finally went to this, it was a parking lot. I mean, it was so, and you can't just tear up somebody's parking lot. And they were able to get permission to do a little digging, and they just serendipitously picked a point. She pointed us where she wanted them to dig, and they found the bones. It was just, it's amazing, amazing story. But in any event, I'm going to tell you a little about Richard III. Richard wants to be king. True. Richard systematically murders everyone in between him and the crown. Richard is killed. So that's Richard III in 3 panels. And so I will wait for just a second more to see if someone now does have a question. If not, I'll be doing the commentary tomorrow. And I don't know about tomorrow night. I was just looking here. We were trying to have a guest who had been ill on Tuesday to see if he could come on tomorrow. If not, we will do a wrap up, but it's going to be at 7. And either way, it's going to be at 7, not at 5. 5 is 1, really close to when the trial ends, and 2, I've got a Thursday night conflict at 5, so I can't do 5 on Thursday nights. But we'll be doing the trial 8:30 tomorrow morning, and then either the guest or a wrap up at 7. And Christine said she has a question way up at the beginning. Amber, can you find it? Okay, here it is. Is it purposeful on the part of the prosecution to not object when they ought? Yeah, because objections can also annoy the jury. If you're up and down objecting, they can feel you're not allowing the other side to get their story in. And you don't, and if it's something like repetitive question, repetitive answer, you might think, gee, they're annoying the jury. Why should I object and stop this? Because the jury's getting more and more exasperated with what they're doing. I'll let them continue to do it. So that's one reason why one side, whether it's the prosecutor or the defense, might not object. Now, allowing the defense to go outside the scope of the direct, that's a little more iffy. Usually they're a little more more willing to get up and object when that happens. And I don't have an answer to why he didn't, particularly since the judge offered him, the prosecutor, the chance then to go into what the defense had opened up, and he elected not to. So he didn't seem to want the defense to fall into a trap so that he could then say more. That didn't seem to be it. It may just be a style. I said today, for those of you who watch the Adelson trials, that the prosecutor, Georgia Kappelman, does not object, and she could. There are questions that are beyond the scope. There are questions that are speculative. Sometimes it's repetitive, and she rarely objects. And that's her style. It may be the style of the lawyers in Leon County. But certainly, sometimes you don't do it because you don't want the jury to be annoyed at you for what they might perceive to be keeping information from them that they think they're entitled to hear. And sometimes it may be you think the defense is just digging a hole for themselves, so why object and help them stop digging? Let them keep digging forever till they get to China, for that matter. So that's my answer to that. So I hope this was helpful. If you haven't subscribed, please subscribe. It helps the channel, and the channel could use all the help it can get. Hit like if you liked it, and if you're not a member and might want to think about being a member, we're doing some extra things with the members these days. Please become a member. And you want more mahjong updates? Yeah, I'm not sure. Well, you know what? Tomorrow, because it's too late today to do it, I'm gonna have to find out, and we'll do a poll on how many people want updates on mahjong and how many people feel that would be like watching that black screen and see those little lights go by. And so we'll do our first poll. I don't know how to do a poll. I'm sure Amber knows how to do a poll. We'll do a poll and find out, whether that's a good thing or a bad thing for people who watch. Ciao a tutti.